Protection Act goes too far, that it will not be constitutionally sound, and will set the movement of protecting the unborn back several decades. Thank you for allowing me to speak to such opinions. Some have said if you are truly pro-life, you would introduce legislation to protect the child at the point of conception. Yet in the same breath have said this measure goes too far. The response is simple. I will work to defend and expand protection of the unborn child in any and all ways possible. These notions are not in competition with one another, but are aimed at achieving the same goal. I will support the fetal pain bill as quickly as I have supported the post-viability ban and all other pro-life measures we have achieved through this great legislature. The heartbeat bill is most important because this bill will change the terms of the debate in the Supreme Court's own language, and that progress will lead to vast life-saving measures across the nation. Many who suggest this bill goes too far and succinctly debate we should be protecting from the point of conception are also quickly jumping on board with a bill aimed at protecting children around the 20-week mark. In my opinion, this is equivocally the same motion at a different degree of development, thus making the argument invalid. Some have printed, some have verbalized the Fetal Heartbeat Protection Act to be unconstitutional. This bill has been written by some of the most brilliant minds in the pro-life movement alongside lifelong constitutional attorneys. In fact, in Issues in Law and Medicine, Gregory J. Roden, JD, noted a shift from Gonzales versus Carhart. He now says indicates that a heartbeat approach will work. He bases that opinion on the following. Given the court's previous strict adherence to the term potential life and synonymous expressions, 310, the plain language, and Gonzales affirming the actual life of the unborn child is startling. So too is the declaration that this is no longer a contested issue. Said agreement was reached about in a lower court decision leading up to Gonzales, Planned Parenthood Federation v. Ashcroft, 311. There, the United States District Court for the Northern District of California, in its findings of fact, made the definitive statement the fetus may still have a detectable heartbeat or pulsating umbilical cord, and when the uterine evacuation begins, and any D&E or induction, and may be considered a living fetus, 312, the Supreme Court accepted these findings, noting that the parties in Planned Parenthood Federation agreed with that conclusion. 313, consequently, the Supreme Court has now again embraced the idea that there does exist medical evidence which allows a court to make a finding of fact that life exists in the womb. Ergo, the procedure implicit in any plea of pregnancy are no longer in conflict with the Supreme Court abortion jurisprudence. Roden explained 4 decades of cases that viewed the child in the womb as potential life. 3 pages and 34 years of court citations, which were provided to the Health Committee. But in Gonzales v. Carhart, for the first time, the Supreme Court admitted as a finding of fact that not a potentially living fetus, but a living fetus is recognized from the time of a detectable heartbeat. Not only is this a finding of fact, it is an undisputed finding of fact. Even those in favor of legal abortion on demand agreed with this fact, now recognized for the first time since 1973 by the United States Supreme Court. That is why the time is right. In order to expand protection of the unborn, we must ask for it. This bill is designed specifically based off of court precedents and is aimed at the court's own findings as a direct intention to change the debate based off of their own language. There has never been a better time than now to push the discussion of the state's interest to expand legal protection for the unborn child. For those who claim this legislation will set the movement back, this piece of legislation does not make any progress vulnerable, no more so than any other pro-life measure ever has. To address such concerns, this particular legislation has even included a severability clause to protect all other existing pro-life laws from being reversed. If we are intimidated by a challenge, we wouldn't pass any pro-life legislation, since all of our gains in protecting the unborn have been challenged to some extent. As legislators, we cannot act in fear or concern of what may or may not occur. If our legislation reaches the courts, we must always do and enact what we know to be right. The Supreme Court in 2000 struck down the partial birth abortion ban, and in 2007, it upheld it. And for the first time since 1973, a brutal method of abortion was outlawed. That victory was achieved by an Ohio law that the court struck down initially. In 1995, when Ohio passed the first ban on partial birth abortion, the same arguments we are having today were had then. Legislators don't swear to an oath to uphold Roe v. Wade, we swear to uphold and defend our great Constitution. Our Constitution contains the 14th Amendment, which says, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protections of the law." This bill has a chance with the current court to change the law, for it is based on Supreme Court doctrine.